Charleston Warner.
Thank you, Madam Speaker. I appreciate it's a pleasure to rise and speak to Bill C-3. As you know, the original legislation was first introduced in February of 2017 by, it was introduced as Bill C-337 by Ms. Rona Ambrose, the former leader of our party as well as the official opposition. I want to thank Ms. Ambrose for the passionate advocacy that she has taken on this important legislation. I'm also pleased to see that this legislation adopted by the Liberal government earlier this year was reintroduced again now as Bill C-3. Back in 2017, it received unanimous support from the House of Commons and passed quickly to committee. I guess it should come as no surprise then that it would take over 2 years for it to move through the legislative process despite having all party support. Then it would die on the floor of the Senate in June of 2019. Despite finishing the legislative process about the same time as 15 plus other bills at that June, it was held back by this Liberal majority government from receiving royal assent. And why, people may ask? Well, some may suggest that it's to play the same liberal games that the many Canadians despise and disapprove of, and that is so they could rename it and call it their own. This is important legislation, as it is a step forward toward actually improving our criminal justice system, something that this Liberal government has done little or nothing enough of over the last 5 years. This legislation is about ensuring trust is maintained in the justice system, that survivors of sexual assault are respected by the justice system when they do come forward. This bill requires that to be appointed a judge of a superior court, an individual must now commit to undertaking to participate in continuing education on matters related to sexual assault law and social context, including attending seminars. This will ensure that Superior Court judges are equipped with the knowledge and skills required to address sexual assault trials and ensure that survivors are treated with dignity and respect. It also provides them the training to not feed into the myths and stereotypes that often cause women to hesitate coming forward. Personally, I would have preferred that in addition to the new appointments to the bench, that all current judges sitting at every level of court that adjudicate sexual offenses in this country be required to participate in continuing education on these matters as well, in the same way that this legislation proposes for new Superior Court appointments. This bill will also require judges to provide reasons for their decisions on sexual assault cases. This is good as it will give more information to victims and improve transparency for the justice system and the public who watch it. As a former police officer who has given testimony in a wide variety of criminal cases, including numerous sexual assault cases, I have the utmost respect for the significant challenge and burden placed on our judges. Every day they are tasked with appropriately applying the law to determine guilt or innocence as they adjudicate criminal cases. And while Canadians enjoy the best justice system in the world, it is not without its flaws. Judges, after all, are human, like all of us, and are given the incredible responsibility of applying laws written by other humans, namely us, parliamentarians in this House. And we know that sometimes those laws can also be flawed. We put a great deal of authority and trust in our judges. And so ensuring that people who take up this challenging post are properly equipped, we must ensure that they have the necessary training and knowledge to fulfill those responsibilities to the best of their ability and to the expectation of the Canadian public. This training would eliminate misconceptions and myths and stereotypes that often prevent victims of sexual assault, almost always women, from coming forward and pressing charges against their attackers. Madam Speaker, this is not a minor issue. The number of sexual assaults that occur in Canada and are never reported are staggering. Statistics Canada reported that only 5% of women who were sexually assaulted come to the attention of police. 5%. Why? I suspect one of the many reasons is because of their lack of confidence in our justice system. Far too few of these crimes are reported, and of that 5% that is reported, only 21% led to a court case. There are many factors for this, including what evidence might be available, how it might be prosecuted, witnesses that are available, any corroborating evidence, attitude of the justice participants, how judges approach the issue, and maybe many others. Of the 21% that actually get to court, of the 5% who actually reported being assaulted, only 12% of those cases result in conviction. So think about that. That is 12% of 21% of 5%. In other words, there is a better than 98% chance of not being convicted of sexually assaulting another person in this country. That is unacceptable, Madam Speaker. Unacceptable. Finally, of all those convicted of sexual assault, only 7% result in a prison term. These are terrible crimes, and they have lasting, lifelong impacts. Getting a conviction on sexual assault, let alone having someone sentenced, is far too rare. And most victims of crime and violence and sexual assault will usually prefer not to relive the experience over and over again in our courts, living through the trauma multiple times. Like I said previously, Madam Speaker, I have investigated many of these crimes, sexual assault crimes. It's heartbreaking experiences of listening to victims that are further exasperated by our justice system. They feel they're not being believed. The intrusive nature of the evidence collection process, retelling their experiences repeatedly over and over again. Sometimes limited victim supports, lack of convictions reduce the victim's willingness to come forward. And then if they are convicted, many victims don't feel that the sentence that is given out fits what happened to them. But Madam Speaker, this bill is the kind of thing that governments should be doing, working to improve our justice system, working to support victims with better services, and working to put criminals who assault others to be held accountable and in jail. Support for victims has been sorely lacking in the last few years, and there has been lots of support for criminals, including reduced sentences for some serious and violent crimes, but limited on our victims. The Canadian Association of Chiefs of Police noted in their brief to Parliament on Bill C-75 that some criminals, if given reduced sentences, would mean eliminating certain information being entered into the Canadian Police Information System, including DNA. When the conviction is considered a secondary offense, it eliminates critical information that then limits the ability for police to track and catch that criminal if they commit other crimes. As the CACP put it, this would have direct negative impact on police investigations. And Madam Speaker, I would add on public safety. Canadians should not live in fear. Canadians, young women should not live in fear. Victims and their families should not be living in fear. They should have trust and confidence in our justice system. Victims and their rights should always be put ahead of the rights of criminals. Canada's Conservatives recognize that far too often the justice system fails to respect the experiences of victims of sexual assault. It is time, Madam Speaker, that we ended comments and attitudes like that of our Prime Minister, where he said that she experienced it differently. Those kinds of excuses allow sexual assaults, sexual harassment to be normalized. Calling it out is a duty of all of us. Acting to stop that kind of behavior is the responsibility of this House. My hope is that this bill will be the first step of improving the treatment of victims, increasing the conviction of sexual offenders, improving public safety, and developing the trust and confidence of Canadians in our justice system. Thank you, Madam Speaker.
Questions et commentaires, questions and comments. The Honourable Parliamentary Secretary. The Honourable Parliamentary Secretary to the Minister of Justice.
Thank you very much, Madam Speaker. And I want to thank the member from Medicine Hat, Cardston Warner, for his contributions to today's debate and in Parliament, but also for his service in the past as a police officer. As by way of comment, I would just indicate that in terms of crafting this bill, we're always looking to protect the critical constitutionally important principle of judicial independence. And apropos of his comment about judges at every level of every level or every jurisdiction and every court in the land, we don't at the federal level have the ability to intervene directly with respect to provincially appointed judges. But I think what we can do is set an example at the federal level of what we are trying to do and the importance of judicial education on sexual assault law and in social context. So my question to him is this. Given the importance of this kind of bill and this kind of training, would he commit to working to get this expeditiously to the Standing Committee of Justice, and secondly, to also working with his colleagues in the Alberta government, including Premier Kenney, to ensure similar types of training is also delivered provincially, as it is now being done in Prince Edward Island? Thank you.
The honourable member for Medicine Hat, Cardston Warner.
Thank you, Madam Speaker, and I thank my colleague for his question. Yes, absolutely, it's necessary to work collaboratively, and I think the steps of this House to ensure that at least federally this is done, and working toward all provinces having this as a requirement of anyone sitting on the bench would be a long way to serving the justice system and victims. As for expeditiously moving this through this House, I would push back and say this had the opportunity to be passed in the last Parliament. It was introduced in February of 2017. It was 2 years to went through the process. It was at the Senate. It did not receive royal assent. Why? Because this government did not push it forward to receive royal assent. And I wonder why. So now we have a bill that we, of course, support and want to debate and make sure that we get it right. We've waited now 3 years since this was introduced nearly, and so it's important that the bill move forward, but move forward in a way that serves the best needs of Canadians, not this Liberal government.
Questions et commentaires, questions and comments. The honourable member for Fundy Royal.
Thank you, Speaker, and I want to congratulate my colleague on an excellent speech, and I appreciate his input and his background and perspective on it, and his support for this very important bill. One of the figures mentioned was about only a small percentage of cases involving sexual assault being brought forward. And I wonder if my colleague, in his experience and background as a police officer, could elaborate a bit on why he thinks that is the case and how perhaps this bill could help in that regard. Thank you.
The honourable member for Medicine Hat, Cardston Warner.
Thank you, Madam Speaker, and thank you to the Justice Critic and my colleague for the excellent question. There's a number of factors that I believe inhibit the successful prosecution of sexual assault cases. And they're vast. It can be the police officer may not have the experience necessary or the attitude appropriate to investigate this. It may be that the prosecutor is overwhelmed, undertrained, and so may not give it the attention it requires. It may be that witnesses are reluctant, that the victim is reluctant. But in those cases that actually get to court, it's incredible to see that the system is tilted. And I appreciate the balance of probabilities and the whole issue of beyond a reasonable doubt, or beyond any doubt for conviction. But I have had great evidence that has been put together, incredible witness testimony, DNA evidence, everything there, and the judges sometimes, for various reasons, will not convict. And so I think that the more training that they have, the better it is for everyone.
Une toute petite dernière question.
One quick last question from the honourable member for Lac-Saint-Jean. Thank you, Madam Speaker. I'll go more quickly than possible since the beginning of the day. We've asked questions about why we should there was no acceptance of this bill quickly to send it to the Senate as quickly as possible, and I would like my honourable colleague to explain why the debate is so important today that shouldn't we move quickly to accept it? Thank you very much.
Medicine Hat, Carlston, Warner, a few 10 seconds.
I think that's a question that we should ask the government, why they dragged their feet for nearly 3 years on this bill. Why it didn't get the push that it should have. And today, I didn't get a chance to speak to it last time. I get a chance to speak to it today. I think it's important that it be debated further in committee. There may be amendments that can be made that makes this even stronger than it is today. So I think it...
Reprise du débat.